Hoffman, and I am going to be leading this discussion. And I hope you will all be active participants because this is a topic that requires a significant amount of dialogue and sharing of ideas so that we can all understand the different perspectives. And so if we can, Matt, bring up the first slide, that would be great. We're going to be talking about an issue that is, let's face it, very, very sensitive emotionally and very significant both ethically and legally, starting with the title. Confidentiality of the treatment records of rape victims and interdisciplinary discussion. So in preparation for tonight's program, Dan Arshak, who you'll be hearing from in just a few minutes, pointed out to me that it is inherently prejudicial to refer to the individual whose medical records we are going to be talking about in the case study as a rape victim, because that's prejudicial to the defendant who is a defendant in a criminal proceeding. More on that later. So understand, for example, that we in the hospital world, my perspective on this, treat someone who shows up at the emergency department with a complaint of having been raped as a rape victim. But when we transition back and forth between the different disciplines that you will hear from tonight, bear in mind, and there'll be a point about this in the presentation, that the individual whose records are at issue is variously a rape victim, a rape survivor, and a complaining witness in a criminal case where the defendant is presumed to be innocent. So we have to acknowledge all of that right at the get-go before we proceed into the rest of the discussion. And Matt, for some reason, I can't advance the slides. There we go. So here we are for our discussion, and we're going to spend an hour and a half, about half of that time being our discussion, and that will be among the group of us, but also all of you. So please feel both welcome and desired to enter any questions that you have in the chat box, and those will be handed off to us by the miracle of electronic commerce, and we'll address as many of them as we can tonight. If we don't get to your question or comment, rest assured, I will follow up with all of you afterwards. Matt, oh, you're advancing the slides. Okay, so this is the required legal notice for those in the audience who are getting CLE credit for tonight. This is the description of the steps that you have to follow to get attention. And at the bottom, the most important instruction, which is to reach out to Athena Fontenot from our program so that you can get any questions answered about the paperwork that is required. Matt, can I get the controls back? No? YouTube. Okay. So who are you going to hear from tonight? It's an interesting group. I obviously feel that way because I assembled the group. I will be presenting the perspective of a hospital attorney, ethicist, and compliance officer whose responsibility it is to deal with requests for patient medical records on all of those bases. Dan Arshak will be sharing his perspectives after a very lengthy career as a criminal defense lawyer, as one of the founders of the Bronx Defenders organization that provides legal representation to the indigent in Bronx County. The Honorable Elise Lazansky, who is a judge in Westchester County in the town of North Castle, and also a court attorney in Bronx County, and also a former prosecutor in Westchester, will be sharing both of those perspectives as a former prosecutor and as a judge and a court attorney who has to fashion decisions about the kinds of issues we're talking about. LaShawn Rivera is the executive director of the Columbia University Sexual Violence Response, which is the advocacy organization that provides services to people who have been victims of sexual violence, and she'll share the advocate's perspective. And Bob Klitzman, the academic director of our bioethics master's program at Columbia University, who is also a faculty member at the Mellman School of Public Health and a psychiatrist by training, will be leading us off with the perspective of a clinician who has a patient who is the complainant, and concerning whose medical history the defendant is making the argument that he, in this case, is entitled to access to her, in this case, medical records. So that's our agenda. We're going to go through the perspectives of each of the speakers and then gather together as a group to have a discussion so that we can share comments and criticisms about each other's priorities and professional obligations. So let's go to the next slide. Oh, I can do this now. Excellent. Whoops, and I just went too far. So first things first, let's remind ourselves why we're here, why this discussion is important. The question we have to confront, all of us, is what are a lawyer's, any kind of lawyer's, ethical obligations when considering issuance of a subpoena for the mental health records of a sexual assault victim, survivor, and complaining witness. Oops. And the crux of the reason for this discussion, why this is an ethical dilemma, is that on the one hand, we have as a society the strong conviction that we should believe the victim and that victims need to be heard and need to be treated respectfully, balanced against the sort of most central tenet of criminal law that the accused is innocent until proven guilty. And those two values are in stark contrast and relief and really conflict in this situation. So tonight you're going to hear from all of us about our various perspectives on how to resolve what you could think of as an unstoppable force meeting an immovable object. So from the legal perspective, because this is first and foremost a continuing legal education discussion, though important not just for lawyers, but certainly for lawyers, what we're talking about in the law, and this will be a theme running through all of the presentations tonight, is this section of New York State's mental hygiene law, section 33.13, which in pertinent part, we start with C, says that where patient records are concerned, such information about patients or clients shall not be released by the offices or its facilities to any person or agency outside of the offices, except as follows. And the relevant provision for us is number one, pursuant to an order of a court of record requiring disclosure. Here's the important part, upon a finding by the court that the interests of justice significantly outweigh the need for confidentiality. Emphasis on significantly for me, because that's my perspective as a hospital lawyer and a clinical ethicist who advocates for patients. I suspect Dan and Elise will have a slightly different perspective on what the word significantly ought to be interpreted to mean. Now, there are some really important legal ethical rules that have a bearing on how all of us who are lawyers have to approach our representation and our advocacy for whomever is our client. And perhaps most important of these is Rule 1.1, which says in pertinent part, a lawyer shall not intentionally fail to seek the objectives of the client through reasonably available means permitted by law and these rules. And what that means, and that is really a restatement of the obligation of a lawyer to be an advocate, but what it doesn't say, which has sort of fallen out of favor, is the notion that a lawyer has to be, quote unquote, a zealous advocate, as that term came to be interpreted in prior years and prior versions of the rules of professional conduct. Next, we have to consider Rule 1.2, which says that a lawyer may refuse to aid or participate in conduct that the lawyer believes to be unlawful, even though there is some support for an argument that the conduct is legal. This is the counterpoint to the notion that lawyers, as zealous advocates, have to advance every single argument available to them. And what that says from an ethical perspective is that lawyers have discretion to decide when it is appropriate to press this or that legal right and advantage. And that's set forth in Part G. A lawyer does not violate these rules by avoiding offensive tactics. And of course, the question then becomes, what is an offensive tactic and what is merely an aggressive tactic? And that's really what we're here to talk about tonight. And finally, there's Rule 4.1. And Rule 4.1 is the lawyer's obligation of truthfulness and duty to avoid misrepresentations. And 4.1 says that a misrepresentation can occur if the lawyer incorporates or affirms a statement of another person that the lawyer knows is false. And that's relevant to our discussion tonight, as we're going to get into when Bob Klitzman does his part of the program, in the lawyer introducing statements made by the defendant, which Dan will talk about some, that are presented as the basis upon which the court ought, from the defendant's perspective, to conclude that the equities substantially weigh in favor of disclosure because of the defendant's right to due process. So those are the rules of professional conduct that we need to keep in mind as we dive into our case study, the beginning of our discussion. Let me say a few words before I turn this over to Bob. First, this is an actual case. This is something that came to my attention just a couple months ago, involving one of the hospitals that I advise. I advise hospitals across the state and across the country. And this was a phone call that I got from one of them, followed by an email, because they had received an order to show cause. More on what that is when we get into our discussion. So you have in the materials that we shared the actual order to show cause, the legal brief submitted by the defendant's lawyer, by the prosecutor, by me on behalf of the hospital, and the actual decision from the court. And you will notice immediately that I redacted some of the content, not because there is a legal or professional ethical obligation to do so, but really because it doesn't serve my client, the hospital's purpose. And I don't think it serves my obligation to be an advocate for the privacy and confidentiality of the complaining witness, to use that vernacular in this legal context, to have the identity of the actual complaining witness, the victim, or of the defendant in this case, or the judge or the hospital identified. And that's why you'll see that there are these redactions. So this is the order to show cause. For those of you in the audience who are not lawyers, this is how an attorney for a party in a litigation, criminal or civil, can initiate a request for an order of the court, in this case, an order being sought under 33.13 of the Mental Hygiene Law, to get access to records that, let's be clear, should be confidential in virtually every other context and circumstance, right? So the notion that we're talking about releasing records that include behavioral health, mental health, or psychiatric treatment is an outlier. This comes up once in a while in child custody matters. I actually handled a case not too long ago where the records of a treating clinical psychologist were requested in that context. But you should understand, this is the exception, not the rule of patient confidentiality, specifically with regard to clinical psychologists, for reasons that we'll get into in a little while. So, Bob, I would like for you to walk through the next couple of sections of the papers and take a closer look at what it is that the defendant is asserting against the complaining witness, the victim, about her clinical history and background and what you make of that in terms of a compelling argument that she is somehow compromised as a witness, and therefore this information should be allowed to be used during the course of the criminal trial because it evidences something about her reliability, credibility, veracity, etc. So, Bob, I give you the floor.
Great. Well, thank you, David, and thank you for the invitation to participate in this evening's event, and thank you for organizing it. And I'm really honored to be here with my co-panelists, Elise and LaShawn and Daniel. This is a key passage that appears here, which is and again, just for those who may not have had a chance to look at this, basically, as I understand it, a woman alleges she was raped, says she was raped. Apparently, there was enough evidence of that the police then filed the criminal charge against the gentleman who is now the defendant. And his lawyer then wrote this, saying that requesting the records of her mental health treatment, saying the records requested are material and necessary for this action, that they will provide information relating to the complaining witness's mental health and emotional capacity. The requested material may also disclose whether in her mental health treatment, the complaining witness underwent hypnosis or other treatment that would affect her credibility or even her competence and ability to take an oath. Therefore, the need for disclosure of the requested material significantly outweighs any potential injury to the patient, to physician-patient privilege. I don't know if you have the rest of the text on the next slide.
Absolutely. So before we move into the sworn statements that support that request, Bob, tell me, as a clinician, what do you make of this? And does this sort of, does this bother you, or does this seem like a legitimate argument from the psychological and psychiatric perspective?
Asked like a true lawyer, his argument raises several problems. First of all, confidentiality in mental health treatment is crucial. So again, I don't know if this woman had any mental health treatment. He alleges she did. He alleges elsewhere that she had, quote, depression and anxiety and a hospitalization and suicide attempt, I think. But the problem is that mental health treatment depends on trust and confidentiality. And that's because if I or someone else has a mental health problem, there's a lot of stigma around depression, around substance abuse, around suicidal ideation. And so various kinds of thoughts that may be seen as incriminating to oneself. But psychotherapy depends on the patient being completely honest so that the therapist knows what the problem is to then know how best to treat it. So if there was no confidentiality, if patients with mental health problems knew that when they went to their therapist, the therapist was going to tell other people that they were depressed or anxious or suicidal or use drugs, knowing that that could be drug use, for instance, may be illegal. They could get in legal difficulty with that. Depression remains stigmatized. People feel, well, if someone was depressed, even in the past, maybe I shouldn't hire them for a job. These are real areas of discrimination. And so the trust that we need for patients to divulge information to get better really has to be sacrosanct. And if it's known that, well, that therapist over there released information, patients may feel, well, I may not be able to trust my therapist either. And so confidentiality is really key. Now, there have been a few exceptions that have been established. One is through the so-called Tarasoff decision, which is based on a case in which there was a young student, Tatiana Tarasoff, at University of California at Berkeley, and there was a guy who was interested in dating her. She was not interested. He was in therapy and told the therapist that he was going to kill her. The therapist was concerned and told the University of California, Berkeley campus police that there were concerns about this gentleman. The police then took him into custody, questioned him. At that point, I'm not sure exactly whether it was a few days later, perhaps, the student seemed fine, was released, and then the student very sadly killed Tatiana Tarasov. The therapist did not notify Tatiana or her parents that there was a young man interested in killing her. And because he felt that this was confidential information, this is information that the young man had given in therapy. And so the court ruled that if there is, and I'm paraphrasing, basically acute, clear danger to oneself or someone else, that principle of immediate direct harm outweighs confidentiality, or may in certain cases. Similarly, there's a case of child abuse. So I once had a patient actually who told me that she was abusing her child at home, that she would get angry and would take an electrical cord and repeatedly hit the child. And I spoke to my supervisor at the time. I was in training, but unfortunately we had to alert authorities that there was an abused child there. When I told her this, she actually understood. In some ways, she appreciated that we were doing something about the problem, that she felt really unable to control these impulses, and was sort of glad that we were sort of going to help her out with it. So there are those exceptions. This case that David has presented here, and in this kind of a case, that standard is not met, I would argue. So it's quite the opposite. So it's not the case that this woman is in immediate, risk of injuring someone, of killing someone. Far from it. She, if anything, is the victim here, obviously. And so I would argue that there is no reason to support releasing her records in this case on the part of the judge. The notion that she may, if she was in hypnosis, let's say, have decreased credibility or competence is also, I think, not a compelling argument, and is grossly problematic, because even if one were in hypnosis in the past, let's say 5 years ago I underwent hypnosis, that does not speak at all to my ability today to be a credible witness. Just like if I was depressed 5 years ago or in treatment 5 years ago, that has no bearing on today what my situation is. I may have been well treated since then. She may not have any mental health problems at the moment, even if, and again, I don't know if she did or didn't, but if she had, even if she had been under hypnosis, one could argue maybe for those few minutes of hypnosis, she may not have been fully in command of all her faculties. But that was probably, if she had been hypnosis, could have been years ago. We don't even know if she was. So for all these reasons, I think that this is not I would not support this by any means, and I see gross problems with this, and I'm happy to elaborate on that more.
Yeah, so let's now look at the evidence, the sworn statements, what we lawyers call affidavits, that supported this application to this judge at this courthouse. And Bob, if you could just run through the information on this page and the next, and tell us what you think of the factual circumstance that the defendant argues gives rise to the need to violate this individual's patient confidentiality.
Well, here he is saying that she would come and have sex with him over a several month period. Are you going to show the next slide, or?
Yeah, just trying to get my. There we go.
Right. So she took pills. We don't know what kind of pills. Could have been Tylenol for all we know. Could have been Motrin because she wasn't feeling well. She said they were for anxiety and depression. Even if they were for depression or anxiety, for instance, that I would argue would not affect her ability to be a quote, competent, credible witness. A large percentage of America is on some kind of medication for mental health problems. After this, point 4 here, on the next visit from after the occasion I saw her take the pills, we had intercourse as always. Subsequent to having intercourse, we had a conversation. Next slide.
Yep.
She told me she wanted to change her name. When I asked her why, she told me she'd been raped by her father and she did not want his name. So again, this is terribly unfortunate that she has been raped by her father. This is a horrible thing. But again, that in no way makes her less credible a witness. or also doesn't speak to, and in fact, one could argue if someone had been abused by a parent, there's probably a higher likelihood that they have depression and anxiety, but that by no means makes her less credible as a witness, etc. And then he just says, I never raped or assaulted the person, he says. So I would argue, again, even with this information, it's not clear that her treatment records, her mental health records, are at all relevant to this case. She might well have been depressed or anxious because of being raped or because of any other reason. And of course, depression has some biological element to it often in many cases. But again, that doesn't speak to a compelling need to override the confidentiality by any means. And there's no reason to think that her treatment records would be relevant here. I would add, however, that I'd be concerned just reading this, whether this is an attempt to sort of smear her in some way. In other words, even though the records would not show that she's not a credible witness in terms of the factual information, even if she was under hypnosis, and again, hypnosis is rarely used anyway, could have been years ago and not relevant, but, oh, she's depressed, she's crazy, there's something wrong with her. Unfortunately, because there's very little understanding, a very poor understanding of depression and mental illness still, there are courts that may think, well, even though there's no factual objective evidence that her credibility is reduced, we know that in these kinds of cases, there are judges and juries in rape and assault cases who unfortunately blame the victim. And there are power elements of men having more power in society, et cetera, et cetera. These are major concerns. So I'd be concerned that this is really sort of an effort just to sort of, for lack of a better term, smear her, discredit her, not on any factual evidence, but just the mere fact, oh, she has a mental health history, oh, she was hospitalized, she must be nuts, etc. We saw this, if you remember, even when Anita Hill was criticizing Clarence Thomas, and they were saying, "Oh, she's crazy," etc., as a way of sort of making ad hominem arguments or dismiss the legitimacy of whatever she might say.
Well, there you go, the psychiatrist's perspective, and thank you, Bob. We'll get back to some of those questions in our discussion. And that brings us to our question. What rights does the mental hygiene law provide to criminal defendants, and how should those rights be viewed from the perspective of the bioethical privacy rights of rape victims? So we're talking essentially about this balance. I think Dr. Klitzman did an excellent job of outlining the clinical reasons why A, confidentiality is important, and B, the arguments advanced by the defendant in this case, which is not necessarily representative, but are the facts that I had to confront, don't meet the threshold. But there's still the larger question of what does the law provide? Let's go back again to 33.13 about the standard for defining the interests of justice significantly outweighing the need for confidentiality. And that brings us to the criminal defense lawyer's perspective. So, Dan, please don't hold back.
You know me well enough. Well, I'm very pleased to be here this evening, and it might interest some of you to know that David and I went to school together at the Columbia Presbyterian and Einstein Medical Bioethics program back in the Stone Age, in their first year, actually.
28 years ago.
And I learned a lot about ethics and bioethics doing that, and I bring a lot of that work to a lot of that knowledge to the work that I do within the criminal justice system. I've always been a defense attorney, never been a prosecutor, never had any interest in putting people in jail. Certainly in New York, prosecutors spend most of their time putting Black and brown men in jail. I have no interest in doing that. I do have an interest in being a voice and a support to people at their darkest moments. And that's what I do. I don't do the work that I do because the Constitution says everybody's entitled to a defense. I couldn't care less. What I do care about is acknowledging that a person who's been charged with an offense is way over their head. They don't have the words or the skills or the knowledge to address the issues that need to be addressed in court. And so I do that. And I do that zealously. By the way, it's only the New York State Rules of Professional Conduct that has eliminated the word zeal from its rules, and they just took the word zeal out. Now the sentence reads, "A lawyer must also act with commitment and dedication to the interest of the client and in advocacy upon the client's behalf." It used to say interests of the client and with zeal in advocacy. There's no real record of whatever happened to those words or why they disappeared, but they still exist in the ABA Model Code of Professional Conduct. And it is with zeal that I do this work. And that sentence is in the what I think is the most important professional ethics provision that, David, you did not read, and that was Rule 1.3, diligence. And that's where the comment says, and I'm going to read this sentence again, "A lawyer must also act with commitment and dedication to the interests of the client and with zeal in advocacy upon the client's behalf." So what doesn't it say in that sentence? It doesn't say that we protect the interests of the criminal justice system. It doesn't say we protect the interests of an alleged victim. All that it says is that we protect the interest of the clients. It's a singular, laser focus on protecting that one person in this circumstance. And so, I'm a little worried about sounding like the wolf at the door, but I don't, in the work that I look as a citizen in the world, I care a lot about a lot of things. In the work that I do, I'm not engaged with the question of, am I going to hurt the feelings of an alleged victim if I go after their records? It's not my issue. I'm not going to intentionally try to hurt somebody, but I recognize that some of the work that I do will hurt people, and some of the words that I say will hurt people. And I do that only if I think it's in accord with my primary directive, and that is to represent as well as I can that one person in that circumstance. So that's the foundation of the work that I do. And how do we do the work? Well, or I should say, why do we do the work, and what do we need to do the work? The Supreme Court has identified two very important cases. It's Lafler v. Cooper and Missouri v. Fry. And in essence, both of those cases, those were both 2012 cases. Both of those cases make clear that defense attorneys are ethically bound to provide sufficient information to their clients so that an informed decision can be made concerning whether to plead guilty or go to trial. And in order to do that, lawyers need to have access to discovery before those very important decisions are made. The rules recently changed in New York State so that defense attorneys will get this kind of information earlier so that those kinds of important decisions can be made. But asking for, if there's a basis to ask for medical records of an alleged victim, if there's a basis for asking for those, and those records end up being relevant and material and important, my client needs to have access to those and understand the importance of those at the beginning of the case so that these important decisions can be made. And it's not so much, I have to say, Robert, it's not so much because there's any interest in smearing anybody. It's really because in order for a defendant in a criminal case who's looking, and these are very serious cases, a rape case, who's looking at the possibility of spending decades in jail, they need to have access to whatever information there is. And that's why we ask for that information. So, David, I wanted to address a little bit, and I limited to 10 minutes, and I've got about 3 hours of talking to do here. I wanted to, David, give me a notion when I've got 2 minutes left, okay?
You're doing fine.
All right. I wanted to address a little bit the case that's been presented to us, and I have to tell you that's People of the State of New York versus Kevin, and it was a disturbing display of extraordinarily poor advocacy by his lawyer. This lawyer missed the opportunity to make any significant arguments on behalf of his client. The judge saw that immediately, and basically, I take nothing away from the opposition that you wrote, David. It was instructive and useful, and I'm sure the judge enjoyed reading it. But had you submitted a goose feather, the judge would have ruled the same way, because this lawyer didn't satisfy any of the elements necessary for the judge to make any sort of discerning decision.
That's the nicest thing you've ever said about
cited no law at all in his decision, in his argument. And I will say that the judge in their decision cited a case that if there are any lawyers in the audience, I'm going to give you a citation to the case that was represented by a lawyer who actually knew what he was doing or she was doing. It's People v. Velasquez, and the citation is 14 New York Sup 3rd 661, a 2015 case in which the defense lawyer actually hired a private investigator who went to talk to the complaining witness, which is what we do. And when they spoke to the complaining witness said to them, you know, I've had some psychiatric issues over the years. I take some medication. It causes me to have real problems with memory and recall, and I from time to time really misremember things. And that was the allegation that he put in his affidavit to the judge. The judge went through a wonderful exploration of the cases that address exactly these issues, mental health records, and said because the lawyer raised all of the issues that he needed to, I'm going to grant the application for the release of these records.
And Dan, I will save my response for our discussion. But I think you have acquitted yourself marvelously as always, but there are other sides of this discussion to be sure.
Well, there are, but you're asking me from the defense perspective.
Oh, absolutely.
And right, and I get, you know, there's lots of other sides, and that's why we're here. You know. I would say, you know, some significant portion of the work that I do as well is representing psychologists and psychiatrists in the work that they do. And some of the discussions that we have is what should go in my records and what shouldn't go in my records. And are my records sacrosanct? And well, we know from this discussion that their records are not sacrosanct. And in some events, in some cases, the entirety of their records will be obtainable. And
yeah, and I want to discuss the comments you made about investigative techniques, which are really the counterpoint to the confidentiality of the records, because I don't disagree with you that sending an investigator out to talk to the complaining witness, the victim, if she is either inclined to talk or doesn't realize that perhaps it's not in her interest, that's a discussion we'll have toward the end of the program.
sure.
So thank you.
Yep.
And that brings us to the other side of the coin, right? So there is the complainant who, from a clinician's perspective, is a victim. And I asked LaShawn Rivera to come here to talk about the interests of the person who is the accuser from her perspective as an advocate for people who are victims of sexual violence. So, LaShawn, what do you have to say about what you've heard so far? And what should we as lawyers and clinicians know about the importance of protecting victims of sexual assault?
Yes, thank you, David. So first, I just want to thank everyone. I really appreciate being on this panel. I think this is an important dialogue. David, I know when you and I first connected, I shared with you this is a conversation that is happening nationally, but certainly statewide amongst other professionals like myself who are doing the work directly with survivors in the advocacy realm. And so, in just listening to Robert's remarks and Daniel's remarks and thinking about the role that an office like mine plays in supporting survivors. So we work with survivors of all issues. So sexual violence is certainly one of the many. But in addition to that, domestic violence, intimate partner violence, there's a lot of different experiences that individuals may have where they're interacting with someone who facilitates some form of abuse or violence against them. And I think what is really critical to understand is the role that an advocate plays in working with survivors. And I will say, I'm going to use the term survivors. I understand that we're using the terms interchangeably. I'm referring to survivors as individuals who not only have gone through these experiences, but have also gotten to a place where they are seeking, whatever support, whatever that looks like for them to survive the experience, the horrific experience they've gone through. And as Robert shared, we're working with individuals who may be dealing with, as a part of their own reaction to what's happened, suicidal thoughts, different types of, concerns and issues that are coming up for them. But going back to the role of the advocate, we're engaging with survivors at their most vulnerable moment. The role of my team and I is we're responding at the moment of crisis. So if someone calls our 24/7 helpline or they connect with an advocate, oftentimes it's at a moment that is soon after the assault or violence that has occurred. And the first thing they want to know is, if I tell what I tell you, where will this be used against me? They want to know, is it safe? Is it emotionally safe for me to talk to you about what's happened to me? I want to know they want to know their rights. They want to know what options are available to them. Many of them are needing emergency shelter, going back home to someone who has raped them, or going back to a dorm room in a space where a roommate's partner has raped them is not a safe situation. So I just want to bring us into the realities of what's happening with individuals who experience these types of harms, these types of crimes and abuse, and the need for confidentiality, privacy, whatever realm based on who they're interacting with in that moment. It is so critical for them to fully understand what that looks like, what it means to work with an advocate in the state of New York. We are fortunate at Columbia University not only to have sexual violence response, and I'm not just saying that because I work there, but because if you look at nationally, most universities have not had a resource like this established for 30 years on their campus. Most universities, this has become a niche field that has come into existence in the last 5 to 10 years. Columbia University and Barnard College established this in the early 90s. Okay, so this has been something that has been a priority at Columbia and Barnard for a very long time. We received our state certification in 1998. That was the point where sexual violence response could extend rape crisis counselor confidentiality through the state of New York. So talking to survivors in that moment when they make that initial contact and say, I need help, but before I tell you anything, before I tell you what type of help I need to know that this will stay, between us and what that will look like. So when we think about what are the other considerations and why this is so critical, we also have to think about, what does it mean to have releases of information? How do we explain these waivers? How do we explain, when we've gone over their rights and options and they've chosen to engage with maybe a student judicial process on campus, or they've chosen to engage with the criminal justice system or the civil justice system in some shape or form. Our role as advocates is not only to explain all of those rights, but to explain and make sure they're fully informed as best as possible about each of those systems and what it means when they start to share their experience with those different entities. Oftentimes, survivors will ask, if I report to Title IX on campus, or if I report to law enforcement, I want you to be there with me. However, what does that mean with my confidentiality with your office? Do you become a witness? And so we want to explain how our role can shift, what our role is best to be if they're wanting us to maintain that confidentiality. Survivors oftentimes are needing support and needing advocates to liaise for them around different services. Sometimes we're helping connect them with therapists. When we think about, and I really appreciate, Daniel, your point regarding what it means to be imprisoning so many Black and brown men. When we think about the anti-rape movement and who's at the very bottom of the paradigm, it's oftentimes women of color. And so oftentimes when we think about the anti-rape movement and the earliest acts during slavery facilitated by white men against Black women that they owned as their property and had no legal rights, no resources, no support. And we have this evolution of women's rights for children, all of these different factors. And what came in really some of the first shelters in the United States that focused on domestic violence and rape crisis support, we're looking at the 70s. At that moment, there was very few systems established for survivors, particularly to provide that level of privacy and confidentiality for them that they would need in order to seek safe shelter, in order to ensure that their abuser didn't know where they're located. And this is information that will be oftentimes exchanged with a mental health provider and or an advocate or other support systems that they engage with. So when we think about those realities and how limited it is for a survivor to come forward, and then some of our most vulnerable populations are survivors who are also individuals living with disabilities, individuals who are people of color, our queer communities. So when we talk about silence and the need for confidentiality, we also have to think about who are our most vulnerable populations and what does it mean for them to already feel like they don't have access to mental health support and these kinds of services, but then to also have that level of concern regarding, will my records be subpoenaed? Will information that I disclose to this advocate be subpoenaed? Oftentimes when an advocate is first engaging with a survivor, yes, they're talking to them about confidentiality. They're explaining to them information regarding how they can, if they're wanting that advocate to liaise. We use in my office what we call a release of information. I know other offices may refer to it as a waiver. With that, we constantly are talking to survivors about how detailed they can be in that process. If they're choosing to make reports, if they want to request for certain information to be redacted, because there might be that possibility or risk of those records being subpoenaed and or utilized by the defense. With all of that being said, I just want to, highlight this component around the challenges that survivors have as far as the question or the comment around, I'm going to use the term secondary injury or re-traumatization and what that actually looks like. And, you have someone who's already experienced violence or abuse by potentially a party of individuals and or one person. And now we're talking about a system violating and abusing them again by requesting records that may have no relevance to the most recent act or incident that's been reported or investigated, and also may have information regarding other history. It is not often that I've been doing this work for 20 years. I would say it's not often that I've worked with survivors who don't have a previous trauma history with these issues. Unfortunately, the reality of what we know with these issues is individuals who've experienced sexual assault once before may experience it again. And so having that space and opportunity, whether it's with an advocate, a counselor, a therapist, a doctor, oftentimes survivors are disclosing to their medical providers, to be able to talk about those histories, talk about current, recent events and experiences, and not have that used against them in a process can certainly help alleviate the risk or possibility of second injury.
And LaShawn, when we get to our discussion, I'm going to press you on the question whether you can imagine yourself saying to a victim, you should not press charges because of what you have told me would potentially be found out in mental health treatment records. So let's hold that thought for a few minutes. And thank you. Up on your screen are some resources that LaShawn asked me to share with everyone. This will all be accessible on the Columbia Bioethics Master's Program webpage for this program after the program is over. So if you feel a need to have this information at hand, which many of us should, that will be available to you as part of the materials for this program. And now we're going to turn to sort of where all of this comes together, right? So at the crux of all of these difficult ethical and legal questions is the role and the responsibility of the prosecuting attorney on the one hand and the presiding justice, and the extent to which each of those individuals has an obligation in their professional role to advocate for the privacy and confidentiality concerns of victims consistent with the requirements of 33.13 of the Mental Hygiene Law. And I cannot think of a better person to speak to both of these questions than Elise Lazansky, the Honorable Elise Lazansky, who started her career as a prosecuting attorney in the Westchester District Attorney's Office, prosecuting domestic violence and related kinds of cases, and then went on to the Appeals Bureau, where she parsed the legal rights of cases that had been brought before. Went on to become a judge in the town of North Council in Westchester County, where she still serves as town judge. And she is also, because she doesn't have enough to do, a court attorney, the legal brain behind the judge in Bronx County who actually does the research and builds the argument that goes into the decision. So Elise, you've heard a lot, and I'm wondering how all of this strikes you from both of your roles, previously as a prosecuting attorney and now on the judicial side.
Yes, I have never been asked to express any knowledge from the point of view of a prosecutor and a judge at the same time. So I'm going to have to compartmentalize my brain. And just as an initial matter, I want to note that I became a prosecutor, not, as Dan said, because I was interested in putting people in jail or Black and brown people in jail, but to give a voice to the most vulnerable people in society who had been knocked down and victimized by those who are experts at choosing their vulnerable subjects, so that they could heal and confront the injustice and get punishment in whatever measure was just, not necessarily jail. In fact, I would say that in the more than 30 years I've been in the criminal justice system, I think it's a very small percentage, possibly even single digits of cases that end up with jail sentences. In any event, I was a special prosecutions prosecutor. I did sex crimes, domestic violence, and child abuse. And that was not only Black and brown people, it was people from every ethnic group, every class of economics, every color, every religion, because that kind of abuse is not limited to a single class or race. And so now to the law. It's the Sixth Amendment right of confrontation bumping up against the right to privacy of health information. The prosecutor, as Dan pointed out, the law has changed recently, and prosecutors have a much broader role, a much broader obligation to disclose information about their case to the defense early on. That's a good thing. It is hoped that we will, with this new law, increase efficiency and expediency in prosecuting and disposing of cases. I'm not sure that that's really been the result yet, but the wealth of information that's disclosed is a benefit to everybody. So it used to be that prosecutors didn't have an obligation to know about the mental health background of a complainant, and now I would argue that prosecutors have more of an obligation to investigate that. Nonetheless, the disclosure of records is a different question than the disclosure of information, and prosecutors are required to disclose any information that could, it's called the Brady rule. You've all heard of Brady material if you're a lawyer. The prosecutor cannot withhold any evidence favorable to the accused that could impact either guilt or punishment. And that means now under the new discovery law, it has been even, I would say, expanded a little bit to require the prosecutor to disclose any material that tends to impeach a prosecution witness. And that is whether or not the prosecutor gives credit to the information. That is not for the prosecutor to decide whether that information is relevant or not. So when the prosecutor knows of a mental health history of a complainant or a witness, the prosecutor is really only required to disclose that if it could impact on their credibility or on the outcome of the case. And not all, as Dr. Klitzman said before, there are many people who take anxiety medication or who have been in therapy for various reasons. Simply because someone has a mental health history doesn't mean that the defendant is going to be entitled to access their treatment records. In fact, this is a very common problem in sexual abuse cases because predators are really good at ferreting out vulnerable subjects who have a history. They make easier prey. And so a higher percentage of sexual abuse survivors probably have mental health history. Nonetheless, that doesn't mean that the prosecutor has to then turn over the entire psychiatric history. But very often prosecutors don't know where the treatment occurred. They don't know what kind of treatment it was. And so those records are confidential from the prosecutors as well. Prosecutors can't get them without a subpoena, just as the defense can't get them without a subpoena. So while it's important for the prosecutor to disclose information that they know of, which could impact the outcome of the case, and I would say, and there's a lot of case law on this, it's not just anxiety or depression, but it has to impact their ability to perceive the event, to recall the event, and then to testify about the event. Hallucinations could impact that. Breaks, a mental illness that has a break from reality, schizophrenia, or other disorders that where the witness, loses the ability to interact with the reality for a period of time. Those are the kinds of records and information that would be able to be disclosed. Beyond that, the prosecutor does have, I think, an important role in promising the survivor or the witness that they'll do their best to prevent the disclosure of any information that does not impact the case. And because it is important to encourage people to report crimes, to come forward, to testify, and also to encourage truthful and honest therapy. So I think that's the prosecutor's point of view. From the judge's point of view, I totally agree with Dan's point of view about the case that was first put up on the screen, that the lawyer didn't make a good enough argument that was specific. The law really requires a good faith factual basis for disclosing records. And it has to be information that is specific and will impact the case. And even then, that doesn't mean that the records are going to be disclosed. What it means is that the judge, given a really sufficient, factual, good faith predicate of information, the judge could have the records brought to the court for what we call an in-camera inspection, which means a private inspection by the judge to determine what, if any, material in those records would be the kind of information that would impact the case.
And we will get into that discussion in a few minutes, because I'm very interested to hear what you think about the harm of an in-camera inspection itself, because that was actually one of the arguments that I made on behalf of my hospital, which I'm going to get to in just a moment. So before we go any further, for those of you seeking CLE credit for tonight's discussion, this is our first participation code. I kept it simple, patient. Write it down because you have to have it. And there'll be a second participation code at the very end of the evening. You will need both of them in order to get CLE credit. But if you forget, you can always repeat the program online at your leisure, and you'll have another chance to get the codes. But you'll have to listen to this again.
Before you go on to the next presenter, I just want to answer a question that's in the chat about a small percentage of cases ending up in jail time. So prosecutors most often work with their witnesses, their complainants, in fashioning a kind of disposition of the case. And it's a balance between what the witness wants and what the evidence can bear. There are so many, especially in sex crimes and domestic violence, there's a wide range of possible dispositions. And very often in sex crimes, the victims or the survivors know their rapist or their abuser. They have a relationship that's ongoing with them, and they don't always want jail time. Maybe they want treatment, or maybe they just want an order of protection. Maybe there's an anger management program or a sex offender treatment, drug treatment, things like that. And in the Bronx, we are very lucky to have an enormous amount of resources that I have not seen in Westchester, certainly, for alternative dispositions to jail. And most of those, and I work in the domestic violence court, so most of the dispositions there involve a kind of treatment program and an order of protection of some, whether it's a full order, a full stay away, or a limited order. The goal is to kind of prevent recidivism. And I think most people agree that jail doesn't really do that. So that's my. That said, if a complainant is bent on jail time, then the prosecutor has to decide whether the case is strong enough to take to trial and ask for a jail sentence, or whether the expectations of the survivor have to be adjusted.
And in a few minutes, when we get to our discussion, Dan, I'll ask you to talk about the Center for Community Alternatives as a vehicle for accomplishing some of those things, because I think it is an important part of the discussion, because, as Elise pointed out, so often the victim is not going to be completely divorced from the person that she or he is accusing, because many times rape victims know their attacker and sometimes know them intimately. And one is left wondering from the factual recitation in this case, whether this was a relationship that migrated from consensual to non-consensual. And that's part of the complexity. So now I've given myself the liberty of sharing my perspective on this entire situation. And obviously I positioned myself last because I had to consider all of the perspectives that you've heard already, because as the attorney for the hospital, I have physical custody of the records. And to make it very clear, you would not get to the point where I received this order to show cause and made the decision on behalf of my hospital that I had an ethical obligation to oppose it if anyone already had the records, right? If they had been turned over to the prosecutor, this would have been an entirely different discussion, because as Elise pointed out, under Brady, she would have been obligated to turn this information over to the defendant, and then it might have become a question whether the evidence was admissible. But my concern as a healthcare provider organization is to protect and advocate for this patient and every other patient who was going to come to my hospital to get mental health treatment, and to create an environment that, to the maximum extent possible, encourage patients to come forward and seek treatment. And in the context of this particular case, and we'll talk about the larger circumstance, because as both Dan and Elise pointed out, this was a weak argument. And I will take the compliment anyway that I did a good job with my papers, even though it wasn't the toughest fight I've had in my career. But it was important nonetheless to communicate to the court and to all the lawyers that while my responsibility was as an advocate for this patient and every other patient, I made it clear, and you can see this in the papers which I shared in the materials, that I had never looked at the patient's mental health records. I had never spoken to the victim. I had no sense of what the defendant had discovered through their investigation or what the prosecutor had discovered, and it was none of my business. Could I have looked at the records? Legally, yes. Ethically, without the permission of the patient, the victim, the survivor, the complaining witness, I would say no. And I didn't feel the need, because my argument from an ethical perspective, and here I'm talking about my medical ethical responsibility, my job was to make sure that the judge knew that though he, in this case, could, under 33.13, order disclosure of the records, that he shouldn't, not because there was anything in them that was harmful to the victim, that would have supported the argument of the defendant that they were entitled to them. There's good stuff in there. My argument was simply that it would be harmful to all future relationships between mental health providers and their patients, and that for that reason, the judge ought not even to consider an in-camera inspection, because, as Dan generously conceded, what the defense lawyer outlined really was the classic picture of a fishing expedition. And we will have a vigorous discussion about fishing expeditions in a few minutes. I never shy away from an opportunity to cite a prominent case in a whole new context. So in my papers, I cited the United States versus Richard Milhouse Nixon in the case that dealt with the Watergate tapes before the US Supreme Court. And in that case, the Supreme Court outlined the circumstances under which, and I'm quoting here, the public, that is anyone who is accused, is entitled to every man's evidence. That's straight from the decision. By the way, those are the opening words in the recent decision also of the US Supreme Court in Trump versus Vance, where they had to decide, are there limits on a subpoena? And in both Nixon and in Trump versus Vance, the court made the point that there are balancing tests that need to be applied, but you can't go on a fishing expedition. And I argued to the judge in my papers that there was no indication that the defendant or the defendant's attorney already had information which, if admitted in evidentiary form, would support the defendant's position, such that the request to see the medical records was anything other than a fishing expedition. And by doing that, I was able to position myself so that I wasn't doing anything to prejudice the patient. I wasn't doing anything to even infer that there was something in those records that the defendant should say, oh, the hospital's putting up a hell of a fight. There's got to be something good in there, because that was not my role. And of course, I had never been in communication with the patient. The patient was not on notice of the fact that this order to show cause had been served. And so my argument was simply that the value and importance of the confidentiality of the relationship could only be overcome if the defendant, through the investigative techniques that Dan described, had specifically identified information that would be in the records that was necessary or valuable to the defendant's case, to their defense of their position. So that was my view. It is not a popular view among hospital lawyers. Some hospital lawyers would take the position in a situation like this that the hospital has no role, that the defendant and the prosecuting attorney should present their arguments to the judge. And if the judge decides that the records should be disclosed, then the court would be issuing an order obligating the hospital to disclose the record. I don't think that is the role of a hospital in any sense, legal, medical, or ethical.
David, could I interrupt you for 1 second?
Please.
Because what you've charted for yourself was a somewhat removed academic approach to the question without getting your hands dirty. And I get that, and that's fine. And you had a different interest that you were protecting. But let's make it just a little juicier. Let's say that before you responded, in fact, the woman's therapist came to you and said, I don't know what to do, David. She came to me and she admitted that she made it up because she was mad at him, and he reminded her of her father. And you know, I know that she lied. What do you do then, David?
So you can obviously see
and
that Dan,
that doesn't happen ever in the world.
you can obviously see that Dan wants to start the discussion, and we're there, Dan. So let's go back to Bob. Bob, what is your thought about a patient who makes an admission to a clinician and that information winds up in the hands of the institution writ large, embodied by the lawyer? Does that change anything in your mind about your obligation to preserve confidentiality?
Well, I think
when a request to disclose comes in.
Absolutely.
When the request to disclose comes in. So, because I was going to say, my question to David after his comment, before Daniel made a comment, was how is it the information got out in the first place? So if the clearly, if the patient has said to the therapist, I made it all up, I would hope that the therapist would explore with the patient why the patient made it all up and convince the patient that, gee, this is not the best thing to be, taking someone to court for something you made up. How can we deal with this emotionally, psychologically, such that there's another outcome? Whether the therapist would have an obligation or to, as part of that, I should say, to encourage the patient to drop the suit. In other words, if the patient says, gee, I made this, I'm just so angry at the guy, to have the patient think through that, if it does go through to court, if this comes out that you made it up, it's going to be worse for you. I mean, just to think that through. So I think those are issues. One comment I was going to make is, I found it interesting that in all this, that the woman herself in the actual case did not know that any of this was going on, that her treatment records were up for grabs. And the way in which, as LaShawn was saying, is that a re-victimization of her? I mean, where is her voice? Where are her rights in all of this? And it made me wonder, David, too, whether her did her attorney, or I guess it was the prosecution, make a case against disclosure of the records? I didn't see that in the material, but in addition to your very strong statement, whether she was being well represented, and this was a question.
Right. And that is, in fact, an issue. And I'll be interested to hear what Elise has to say about that. But I can tell you from my perspective, I wanted to make the clinical argument in addition to the legal arguments that the prosecutor did in fact make, and they made sort of the standard legal argument. Let me respond to Dan, and then I want to turn to LaShawn. So Dan, as the attorney for the institution, and putting aside the fact that I also served in a role as a clinical ethicist, but as the institution's attorney, if the treating clinician, psychiatrist, psychologist, therapist, counselor had come to me and said, David, I'm very troubled by something that I know about this individual. Can we talk about it? I would have gotten my hands dirty. I would have said, no, we can't, because I ought not to know information about the patient's privileged communication with you, and I don't need to. Because my job is to advocate not on behalf of this particular patient, but to advocate on behalf of the privacy interests of all patients. So I'm gonna actually contradict myself. Before we go to LaShawn, Elise, I'd like to know from you, is it enough for the prosecutor to be presenting the arguments that the patient might advance about her own records? Is the prosecutor in a position to do that, to take on that responsibility as the advocate for the patient?
I think you're on mute.
You're muted, Elise.
I would say no. I think the prosecutor has an ethical obligation to advance the cause of justice, not to only do what the witness wants to be done. But the prosecutor must go into court and demand that the proper predicate be shown for either cross-examination of any past mental health history or for the disclosure of records. The prosecutor doesn't want to weaken their case, but they can't hide the truth if it is relevant to the defendant's guilt. So, it's a little bit of a fine line. I mean, the prosecutor may not know that, probably doesn't know that the witness told the therapist I was
Right.
lying.
Couldn't know.
That's kind of what the trial is for, is to ferret out the truth. and that's most of the time probably how it comes out. You would hope it doesn't get to that point. And I think, in my experience, it doesn't usually get to that point, but of course you never know.
So can we turn to you, LaShawn? I'm really curious to know what your perspective on this exchange that you've been participating in is, from the perspective of the unambiguous advocate. And would you ever tell a victim, or can you imagine a circumstance where you might tell a victim, you should not press charges? Or if you found out that they made up not the totality of the circumstance, Dan understandably went to the hyperbolic extreme. That's what we do as lawyers. But if a victim made up and acknowledged to you making up some significant factual issue, how do you deal with that as an advocate?
So first, I will say I've not experienced that. I've not worked with someone who's brought that to my attention or knowledge. But it's a great question. I have to go back to what the role of the advocate is. We are not the investigators. We're not the attorneys. Our role is not to tell someone whether they should or should not, make a report to law enforcement or any other entity. We have to, based on what they present to us, we have to present all of their rights and options. And an agency like my own, who also has state and federal obligations, we always have to inform them of those rights and options. Now, certainly you constantly hear survivors say, should I do this? They want that advice. And it's really important that we don't step outside of that role, and that we let them know, here's the information. We want you to make as informed of a decision for yourself. We remind them that I can talk to you about the process, what that can look like, where we can be there to support you in order for you to make that informed decision, but that we're very clear that it's not our role to tell them whether they should or should not. And certainly in a circumstance, in another world, if a survivor said, I made this all up, I was angry, as Daniel shared, I was angry with this person, and they reminded me of a previous abuser, I'd go back to what Robert said. We want to connect. That is someone who's in need of help. That is someone who's definitely, by even sharing and disclosing that level of information, shows and reflects that they acknowledge, that they filed a false complaint or a false, allegation, and that they're needing some support. And so even in that situation, again, I've not experienced that in my career. However, in that dynamic, it would be extremely important for the advocate to revisit, let's talk about getting you connected with a therapist. Let's talk about, what kind of support systems do you need in place to help you navigate, how you came up with, this type of allegation, that you follow through, with law enforcement. We would, of course, inform them of what may happen if they've already made a report, and what that might look like if it's proven that they've made a false allegation, and talk to them about how they can alleviate some of that if they go ahead and come forward immediately, and let, whether it's the district attorney's office or whatever entity that they're working with at that point.
If I can just follow up with that, cases don't just go from LaShawn to like the courtroom. There's a lot of investigation that happens. And in an ideal world, the investigation is thorough and ends up with the truth. And a lot of people are involved in that investigation. First, the initial police officer who responds to the complaint, and then there's a detective who follows up, and then the prosecutor investigates. And then if there's a charge filed, the defense attorney investigates and talks to his client, and inconsistencies in evidence are aired before the case gets to trial in front of the judge via motion practice and discussions on the record regarding possible dispositions. So I would like to think that it's rare that someone who has falsely accused someone gets as far as, testifying.
Well, so let me ask you the hard question, Elise. do you feel as if you would want to have requested these records in your sort of assessment and prep of this victim for trial ahead of time before it ever got to the defendant requesting the records? Is that something that you feel comfortable doing with the victim's permission, given Brady and given all of the dynamics of pretrial discovery?
Okay, wait. In the case study that was first shown,
Yeah.
I'm not sure that there was a sufficient factual predicate to review the records based on what I saw.
But would you ask the victim, who you're in some sort of a working relationship with, right? Because they're your complaining witness. Would you ask the victim to give you?
If I'm the
an
prosecutor,
authorization?
you mean?
If you're
If I'm
the
the
prosecutor. I'm sorry, I failed to preface you and your prosecutor.
Wait, let me put that hat on.
Yep, change hats.
I would inquire of the witness before I try to get their consent for the release of records. What's your history? You know, what kind of medications are you on? Is there a possibility that you were perceiving things incorrectly, or you don't remember correctly, or you had hallucinations, or you had a break with reality, or you were taking a drug that prevented you from, perceiving properly? I would want to know all of those things first. And I would only begin to ask that discussion if there was a real flag raised about it. And I'm not sure in this case that I would have done that.
Because the defendant hadn't put enough sort of on the table?
Yeah, anxiety and depression. My father raped me. That's like a typical case, but it doesn't indicate to me that she was not able to perceive the situation properly, or to recall all of the important details, or even to testify accurately. None of that was triggered for me.
Yeah, this is fascinating. Yeah. And before we go back to Dan, because I want to go back to Dan about that investigative question, I'd like to ask you a question, Bob. As a clinician, if a patient of yours who had initially said, I've been raped, and maybe you did talk therapy or medicated to deal with those symptoms, then said to you, it wasn't really the first time we were together. We had been together before, and maybe I misunderstood, or maybe he misunderstood, said things that you thought would put her, in this case, her, in a difficult position as a complaining witness. Would you feel like you have an obligation to tell her, you know what, maybe you don't want to go forward with this prosecution, with being a witness? What's your thought?
So I think that a therapist has an obligation to try to work in the patient's best interests. And if it becomes apparent that what's in the patient's best interest is, if it's sensed that this is not rape, quote unquote, whatever that may mean, or that this is non-consensual, that this was in fact consensual, let's say, that to tell the patient that to go through with a trial in which the patient's going to have to be on the stand, or et cetera, et cetera, et cetera, that may be difficult. So that, and may not be in the patient's long-term interest. So I think to help the patient figure out what's in the patient's long-term interest, short-term interest. Now, there may be uncertainty. I'm not sure if it was consensual or not, or both drinking. I mean, there are gray areas. But I think overall, I defer to some of the lawyers and to Elise about, what threshold you need to make to make a successful prosecution before a judge or a court. But I would help the patient think through what does the patient want, and what's in the patient's best interest. Is it to go to court? Is it to not? Is it to, et cetera, et cetera. Some things LaShawn was saying earlier about, for some patients, it's to get the person to therapy, for instance. That may be the outcome, or to get a court, order protection. So I think that would be, what's in the patient's best interest, and to help the patient think that through would be a goal.
Thank you. So Dan, I see in the chat that there are a lot of questions about Brady material and disclosure. but nobody has the records yet. I'm the only one who has the records. So is there a Brady issue that we're not thinking about? Like, what is the Brady issue if no one who is a party to the litigation has the records? Oh, and I think you're muted. Yes, you're muted, Dan. Wish I had that mute button.
Sorry, I answered the question perfectly, and now I'll do it poorly.
Yeah, that happened to me too.
No, you having information is not a Brady issue. The only Brady issues that exist when a prosecutor has access or ought to have access to information that is defined, actually, as I just typed it in here. Brady material is any evidence favorable to the accused, including evidence that goes toward negating a defendant's guilt or that could reduce a defendant's potential sentence, or evidence going to the credibility of a witness.
Of which the prosecutor is aware.
Of which, right.
Okay.
Right.
So that leads to the next question. If the prosecutor has a good working relationship with the complaining witness, with the victim, and could ask for permission to get those records, is that an ethical obligation of a prosecuting attorney? Dan, and then Elise can respond.
No, not unless the prosecutor already knows that those records contain what would be Brady material. So, you know, if her witness says to her, for instance, I see a therapist. I have trouble remembering things. I sometimes have auditory hallucinations, and I've spoken about that with my therapist. Well, that needs to be disclosed. That's Brady material. That needs to be disclosed. And when it's disclosed, if the prosecutor doesn't on their own request those records, a defense attorney, other than the one that Kevin had, would make a motion to the judge that now we need these records because we've been informed X, Y, and Z.
And Elise, does that influence the way you manage your relationship with a victim when you're in the prosecutor role?
Does that influence what the Brady obligation?
Are you careful about what questions you ask? What questions you ask of a witness?
No, I want to know everything as a prosecutor.
Right.
I think that the good prosecutor does want to know everything, and wants to present a real picture to the jury if that's where it's going to end up. I agree with everything you said, Dan, and I would just add that that those are confidential records even to the prosecutors, and so it may be sufficient for the prosecutor to simply disclose the information to the court and the defense without requiring production of the records. And if and then there's going to be an argument in court between the prosecutor and the defense attorney, and the judge is going to then make a decision whether disclosure of the information as we know it is enough, or whether the records need to be disclosed for an in-camera inspection by the judge to determine if there's anything more that is important to know.
We're running over a little bit, but I just don't want to end this conversation. So, Bob, you have a question, effectively, I think, for Dan and Elise about Brady.
So the prosecutor has the obligation to disclose information that is favorable to the defense. The prosecutor is not entitled under the law and the Constitution to withhold evidence or information that is favorable to the defense. So that's how the defense lawyer knows.
I just thought there might be people in the audience who are not lawyers who may not know something. So that was great to have the clarification. Thank you.
So this conversation clearly needs to go on, but we are beyond our time. And I thank everyone, both my panel, my old and dear friends, and LaShawn, my new friend. The second, I clicked the wrong button. I'm sorry, folks. Give me 1 second. The second participation code is confidentiality. And I think it's as good a place to end our discussion for tonight. But clearly, this is a discussion that needs to carry on. And if anyone has any more questions, please feel free to contact me and I will get you answers from whomever on the panel you have a question for. And if this is interesting to you, if you enjoy these kinds of presentations and discussions, there's plenty more just like this in programs we've done in the past and those that we will do in the future, including coming up very soon at sps.columbia.edu, academics, masters, bioethic events, previous or future events. And I urge you to visit our website. You can just Google Columbia Bioethics. And with that, I'm going to say thank you to all of you, Elise, LaShawn, Dan, Bob, and good night to everyone.
Thank you.